Hello and welcome to the Imprint Weekly Podcast. I'm John Kelly, Senior Editor of the Imprint, a daily news site covering child welfare and youth justice around the country. You can read all of our coverage at imprintnews.org or check us out on Facebook or Twitter at the Imprint News. You can also sign up on our homepage for our free weekly and monthly newsletters. And for professionals in child welfare and youth justice, subscribe to our Youth Services Insider section for a closer look at news on business, policy, and practice. I said last week that we would kind of get back to regular order here, but that's going to have to wait one more week. Apologies on that, some logistical issues. So again, this week we are going to go right to a guest interview. I'll be back, probably do like a mega headlines episode next week to get caught up on everything that's been happening really in 2023, because we haven't done headlines in a bit. So on this week's podcast, Bridget Mary McCormack, former Chief Justice of the Michigan Supreme Court, joins us to talk about appellate work on child welfare and a scathing dissent that she wrote in one of her last child welfare cases that came before the court right before her retirement in December. So let's go right to that interview. Here is our conversation with former Chief Justice of the Michigan Supreme Court, Bridget Mary McCormack.
Today's Imprint Weekly Podcast is brought to you by Accenture. Change is afoot in child welfare. Change that means agencies focus on results for children and keep far more of them safe at home with their own families. Accenture's child welfare team is leading the way in the effort to ensure technology does its part in that success story. Accenture offers cutting-edge case management tools that ensure agencies can see insights that drive decision-making and caseworkers have information they need at their fingertips. Together, these tools help agencies stay laser-focused, reinventing child welfare into a source of strength for families when they need it. For more information, visit www.accenture.com/child-welfare.
We are joined today by Bridget Mary McCormack, former Chief Justice of the Michigan State Supreme Court, who recently left the bench and used one of her last child welfare-related cases to make quite the statement on what she sees as endemic challenges for the system. She was gracious enough to give us this exit interview of sorts. So, Justice McCormack, thanks for joining us on the Imprint Weekly Podcast.
Thanks for having me. It's great to be here.
So before we get into all the weighty issues of child welfare, let's get these folks to know something about you. You got to give me at least one of your favorites. You can give me more if you want. Categories are TV or movie, book, musical group, or sports team. Justice McCormack, what do you got?
Wow. I want to say that it's embarrassing how little of anything I've done in the last 10 years outside of work, but obviously the Wolverines are having quite a season. So right now I'm going to go with University of Michigan football to win it all.
Fair enough. And I should have probably pointed that out. On top of all of your judging and judgeship, you have you this entire time have been a professor at the law school at Michigan?
I have. I regularly continued to teach at the law school until just this fall when I started I have a new academic home at the University of Pennsylvania. So.
Whoa. Okay. All right. Yeah. Well, let's talk before we get into this dissent you wrote and some of your kind of views as you head out of the Supreme Court here. Let's start with how you kind of came to know about child welfare. You were a Root Tilden Scholar at the New York University of Law, which is like the best public interest law scholarship in the country, right? So is that the kind of point where you first met this system and the issues around it, or were you actually one of those rare birds that maybe actually knew something about child welfare even before law school?
I did not know anything about how child welfare cases are handled in our courts before law school. And honestly, in law school, my introduction to it was because I was a research assistant for Marty Guggenheim, who's been on faculty at NYU for a very long time and is, I think, one of the most important scholars and thinkers in child welfare. And he started one of the very first legal clinics in the country where students represented parents in child abuse and neglect cases. There were many clinics where students represented kids, and some even where they, including one at the University of Michigan Law School, where they represented the agency. But representing parents was sort of pioneering back when Marty Guggenheim first started doing it. I actually was not in that clinic, but I was his research assistant, and I took all of his courses, and that was definitely where I first learned about some of the inequities in the child welfare system.
Interesting. Yeah, and kind of preparing to interview you, I noticed that you started pretty much every legal clinic at the University of Michigan except for the child welfare ones, which I know had been up and running already, right?
Yeah, the child welfare clinic in Michigan, I think, had been around for decades before I even arrived in Ann Arbor. Don Duquette founded it. It was one of the first legal clinics in the country, and it's a great clinic. Don't get me wrong. In fact, the current director, Vivek Sankaran, who took over for Don Duquette when he retired, was my student. And then I hired him when I was the associate dean. And I think he's now one of the most important people thinking and working in this field.
So school me and the listeners on how a Supreme Court justice interacts with the child welfare system. I mean, you were there from 2013 to now, right? What
Yes.
aspects of like the child welfare process did most of the cases that end up in your court have to do with?
Yeah, it's a great question, because the truth is, while we review a lot of applications for leave, and by that I mean litigants who are unhappy with whatever result they got in the Court of Appeals, they ask the Supreme Court to step in and take a look at what went wrong in their case. Just stepping back for a minute from child welfare, we review about 2,000 of those a year, roughly about 2,000 of those applications a year. And it's a very small number that we end up doing something in. In most cases, we deny leave. It's not an error correcting court. We can't fix every error we see. We're trying to figure out where there is some need for some clarity in the law, and for the lawyers and the judges and the people of the state of Michigan who need to know what the law is. And we take on those cases. I would say during my 10 years on the court, however, we addressed more child welfare issues than I think most state Supreme Courts do. I have to credit Professor Sankaran at the University of Michigan Law School, who seems to find a way to get involved in every important child welfare case in the state and brings it to our attention. And once he does, we feel like we have to do something about it. So we had a number of child welfare cases that we have considered on the merits over the years, but regularly we see these leave applications, and the leave applications almost always, unless Vivek Sankaran is involved, come from a parent acting on his or her own behalf. They don't have a right to a lawyer at the part of the process where they're asking the Supreme Court to look at their case. So they submit what we call a pro se application for leave. They write up a leave application on their own and ask the Supreme Court to do something about it. Those we see pretty regularly. It turns out when the state takes your kids away from you permanently, you're going to try and do just about everything you can to figure out if you can reverse that. So we see a lot of those. We consider them on an emergency basis. We do think that these cases need to be considered quickly, and so we do that. And the way it works is every justice, or 7 on the Michigan Supreme Court, gets every application, and we do an independent review. And if we think that there is something we need to talk about, we bring it to conference and we talk to each other. And the goal is to try and convince 3 other people to agree with you. That's always the goal. That's the whole ballgame. If 3 people don't agree with me about something, I'm writing a dissent. So.
Can you recall in your time there a pro se applicant on a child welfare issue that actually succeeded in getting you guys to review?
Yes, a number of times, actually. I mean, without remembering the specific details, but there have been a number of cases where a pro se application caught our attention, and we either found a lawyer for that person before we heard the case on the merits, or sent it back for more process, either in the Court of Appeals or the trial court. That happens even not only in child welfare cases, it happens in criminal cases too. Sure. Criminal defendants also have no right to counsel in the leave application stage at the Michigan Supreme Court, and they will regularly file their own applications. And sometimes they get our attention.
Really interesting. Possibly dumb question here, but is it always the case if something has gotten to your guys' attention that termination has occurred, or do you actually hear appeal requests that have to do with some other aspect of the way that the law works in a court?
There are other appeals that come to us, but it is usually, I'm trying to think of an example where we've granted leave in a case that wasn't, where there hadn't been a termination. I can't think of one. Don't hold me to it because I haven't done my research, but usually termination is such a obviously big deal. That is generally what we're looking at.
Right. And certainly there are different aspects of the law that pertain to any one termination decision and how it's followed and all that stuff.
Yeah, that's right. Yeah.
Last question down memory lane here, and then we'll get to the more present. Mm-hmm. What would you say was the most consequential child welfare decision the Supreme Court made while you were there?
It was an opinion I wrote early, I think maybe 2014, where we reversed what had been a long-standing legal doctrine in Michigan called the one-parent doctrine. One-parent doctrine, just to explain it, went like this. If your co-parent had been accused of abuse or neglect and the kids had been removed from your co-parent, the state could also remove them from you without any allegation that you did anything abusive or neglectful at all.
That's
just
insane.
Because this doctrine, this one-parent doctrine, entitled the state to proceed against you as well, which, I think in my opinion, I said just to describe it, rings unconstitutional, right? Just by saying it out loud, you think like, how could that be? How is it that, how could I lose my right to care for my own kids just because a co-parent is accused of doing something neglectful? And we reversed that longstanding practice doctrine that had been operating in the Michigan courts for decades. And I think that was a pretty important decision. In fact, I think it's one of the most important decisions the courts made across all of the cases that we hear and decide. It doesn't get any attention because this is one area of the law that sort of is under-theorized, under-studied, under-reported on, and people don't know much about unless it happens to them. But I think it might have been one of the most important decisions the court made while I was on it.
That is wild. I wonder how many other states have a policy like that.
It's a great question. I don't know the answer. Yeah.
All right. So in November, you all ruled on a case called In Re GM Dixon, in which a mother had sought to appeal the termination of her parental rights up to you guys. The majority ruled that the questions presented in the case did not warrant review at the highest level. I think you'd probably do a better job than me here. Do you want to generally kind of just describe the situation of the mother and the child at the center of this case?
Yeah, and obviously I don't know them personally. One of the weird things about, reviewing just an appellate record is you're just reading kind of the cold words on the page to try and get a sense of real people who have.
But you could, I know what you mean, but you could actually, in the recitation you provided in dissent, this was a case where I think it jumped off the page a little. You could kind of imagine.
I tried to. I feel like it's kind of important to remember that these are real people that, have had really devastating things happen to them. And so I tried to include in my dissent, the majority just denied leave, but by denying leave, they're not really passing on the merits of the case. They're just saying, we don't believe there's a reason for this court to take it. I dissented because I really was moved by what I thought was a pretty terrible result for this particular family. The mother had some mental health challenges. She also had some challenges with poverty. That's not uncommon. Neither of those are uncommon. And over the course of her life as a parent, had to figure out different ways to manage her parenting relationships with her kids because of those difficulties. So she had a number of kids that she had a relationship with, but were living with their dad, and she would see them regularly, and the relationship worked out just fine. And she had another daughter who was living with some friends from church, and she had the same kind of relationship. She would see her daughter weekly, and she continued to have a close bond with her daughter. Her daughter reported having a close bond with her mother. But sadly, she had a new baby, and the baby died during sleep because of allegedly unsafe sleep practices. Also not uncommon. I wish it were, but if you've been a new parent, you know how exhausting it is, and how when you're feeding a baby, it is not impossible to fall asleep with the baby. Mm-hmm. And therefore, the child welfare system entered her life for the first time. She had sort of been managing these difficulties in her own life and managing to maintain close bonds with her children without any intervention from the state until the death of this newborn brought her to the state's attention. And then they focused on this daughter who had been staying with friends from church. And the child welfare system is just, I said in this dissent, I think it only provides blunt choices, right? There isn't a lot of nuance once a parent comes to the attention of the child welfare agency. They give you a plan for figuring out how to, get your kid back. Some of the parts of that plan are quite subjective and leave lots of room for subjective views of the different people involved in your case. Some are slightly more objective, but also difficult when you're just poor. Sometimes finding housing is difficult. But she did everything she was asked. She really did everything she was asked. And at the end of the day, all she wanted was to continue a relationship with her daughter. Her daughter wanted the same. And yet, after a couple of years of involvement of the agency, the trial court determined that she was not in a position to have the child living with her again, and therefore terminated her parental rights, which felt like two choices she wasn't even interested. Neither of them were interested in. They wanted to maintain their relationship. You could do that with a guardianship. You could do that in lots of other ways. But the child welfare system just didn't give them those choices.
I think that last part's important too. I understand it correctly that the caregivers who were actually, essentially parenting this girl also did not come forward like, we need some definitive termination. They did not want that.
No, they didn't. And in fact, neither did. It seemed like all of the people involved were on the same. The actual people impacted, the kid, the mom, and the couple that were taking care of the kid, who, by the way, the kid thought of as her parents. She just wanted to maintain a relationship with her biological mom. Once the child welfare system gets involved, it's the agency and the court that now had other ideas.
I mean, did you have this dissent kind of saved up for a while? Have you been kind of writing this in your head, or was it the facts of this case that sort of, was there a world where this wasn't coming out of former Chief Justice McCormack before she left?
Well, it is the case that I assumed it would probably be the very last child welfare case that I would be heard on. And it is also the case, as you know from reading the dissent, that I took the occasion to sort of focus on some of the harms that the child welfare system as it's currently operating can cause the people who should be assisted by it. So that, there was definitely some thoughts in there that have been percolating for a long time and in the course of reviewing many of these cases. But I did think that this particular case was a perfect example of some of the ways in which the current child welfare system is not really helping the people I think it is intended to help.
Are you a professional in the field of child welfare, juvenile justice, or other family and youth services? Subscribe today to Youth Services Insider, the imprint's exclusive section on all the insider news you need to stay in the know. Funding opportunities, major federal and state policy shifts, interviews with key leaders in the field. It's all available only for our Youth Services Insider subscribers. Sign up for a monthly or yearly subscription today by visiting imprintnews.org/subscribe. Our podcast listeners get 10% off their subscription by entering the promo code podcast10. That's imprintnews.org/subscribe and get 10% off your subscription by entering the promo code podcast10 today.
One of the critiques in your dissent is that when Michigan courts decide on removals, right, from a home into foster care for the first time, they don't have to balance the harm of that against the harm of staying home. So harm against harm. My question on this is that sounds ideologically very sound. Like you shouldn't be able to do one without, you shouldn't look at one without the other. But I can't, as a layman, picture how that process would happen where the judge or magistrate's own gut didn't drive it, which is sort of the issue that we have a lot, or some people have with best interests, is that it just kind of redounds to like the feeling of the person involved. So how would you create a consistent assessment of this harm versus harm idea?
No, it's a great question, and I don't think it's unique to balancing the harm of removal. Like you said, in some ways, many of the tests that we use in child welfare, like the best interest tests, do leave a lot of room for subjective views. But we trust judges to make those judgments all the time. And so I don't know why we wouldn't at least ask them to try to balance the harm that removal might cause, because it's not zero. So why shouldn't it be at least in the equation when a judge is trying to determine, what the safest place is for a kid to be?
Yeah, no. So, in other words, like even if it was to end up being an imperfect assessment or prone to bias, like so many things are, at least get somebody on the record. I saw it this way in terms of one harm versus the other.
Exactly. And, sometimes when you just require a judge to think about it,
Sure.
it can change their perspective. So I
Yeah.
mean, all I'm saying is it feels to me like it should be part of the equation that we should be
Hmm.
asking judges to think through.
Hmm. You mentioned Vivek Sankran, your colleague, also writes occasionally for us, in a few years wrote a piece about how one big problem in child welfare is just simply that judges put these inclinations and priors into the mix too much, and that we'd be a better system in general in court if they were just calling balls and strikes. Do you agree with that assessment? I mean, do you see that in the work that rises up to you guys in the Supreme Court?
Yeah, it's true not only in child welfare cases, but in many cases. The justice system is still administered by humans, right? If this new chatbot can figure out how to do child welfare cases, maybe Vivek is right. We'll be better off because we
Oh
can
God,
strip away
chatbot judges, just
chatbot judges. I mean, but it is absolutely the case that every individual decision a judge makes, she brings her biases to the table. I mean, what I think the best we can do with that, if we want humans to continue to administer our justice system, is training about implicit bias, right? I mean, as long as you are aware of what those biases are, you can hopefully try and mitigate their harm in your decision making.
another issue you take on here is by the way, I will add a link to our show notes for this episode for the kind of brief story we wrote about Judge McCormack's dissent, and also a link to the full dissent, which is actually an easy read. It's not a scary legal brief or anything like that. It's pretty concise. But one thing you kind of take aim at here is just the implementation, I guess. Not so much the concept of reasonable efforts, but the implementation of it. We had one of your judicial brethren on this podcast last year, Judge Len Edwards out of California, who kind of wrote the book on reasonable efforts. Literally, there's a big book behind me called The Reasonable Efforts. One thing he brought up is that, his experience doing training on this, that he feels like judges feel pressure to move cases along, even if they're not really sure that reasonable efforts have been made to either prevent foster care or to reunite, because of the potential kind of financial costs for the system if they did that, if they halted a lot of cases just on what they saw. So, I mean, do you see other problems with the way reasonable efforts is implemented? And that strikes me as an extremely big problem if that's how
Yeah.
people are making their choices. But do you see other ones in here?
Yeah, I do. I mean, I think that some of the things that are asked of parents are really almost impossible to comply with. I mean, some of the ways in which a set of requests is put together are just not within reach. And it just feels it must be so discouraging to be a parent who is not probably ever going to be able to change, what happened that led her to this place, right? The things that went wrong for this mom long before very big tragedy of losing her infant are part of her. And in some ways, the reasonable efforts standard asks the impossible. It asks parents to, I think I said, get into a time machine and like change the past. It just feels a little bit, the ways in which there are backward looking hoops feels like a setup. I don't know. Yeah, I
Yeah,
feel like there's got to be a better way.
I think one thing you kind of honed in on that I had not really considered before was this concept of a worker in the system assessing whether a service rendered
Yeah,
like had the impact that it was intended to have, right?
yeah,
This is like, I guess it would be not unreasonable to say there ought to be somebody who acknowledges you shouldn't be signing people up for services just to get them. So there should
right.
be some sort of like confirmed, completion, but also like somebody saying, okay, this person went through this and maybe benefited from it, but it probably should be somebody involved with delivering the service,
Yeah,
right? Not
right,
not the
right.
caseworker. Yeah, which is that seems like an issue as well. You mentioned earlier that in this case, the daughter in question, she was living with these caregivers of friends from church, had articulated in court she would like to continue living with them. She called them a mom and dad. She wanted the relationship with mom. So separate out the termination that was at the heart of this case. I'm just curious what your view in general is on how courts should weigh the wishes of children in determining, things of this gravity.
Yeah, there's going to be people who know far more about this than I do. I mean, there are people who probably actually have studied this, and I bet there's even some research on it. So, and I'm not one of those. But I think, when a kid is very clear that that's, as far as I'm aware, in this particular case, there was conflicting testimony from other witnesses who said, we think she's just saying that because she's scared, or we think, there's no evidence to make you question that this was the child's genuine wish. And ultimately, the case is about the child, right? I mean, it's about the parent and the child, but to the extent it's about the child, I don't know why her wish wouldn't mean something, right? I mean, it feels to me, obviously, this is another one of those places where we're asking a lot from judges, right, to be able to weigh and determine how much to assign, to a child's wishes. But it seems to me it should be more than zero.
Yeah, that's a good starting point. So this one's a little wonky, but I kind of feel like maybe it's important. You dissented in this case, but used the dissent largely to kind of connect it to these bigger picture issues. The majority of the case ruled that the questions presented didn't need to be reviewed by all of you. So I guess first, what were the questions presented, and did you feel that they did merit review in this case? I guess I asked because it seems important, like the extent to which the state's highest court sees it as their business to kind of scrutinize these kind of aspects of child welfare law.
Yeah, obviously, I did think the question presented should be reviewed, and that's reflected in the fact that I dissented. But the truth is, the question in this case was just whether the trial court erred in terminating the parental rights of this mom, and then whether the Court of Appeals erred in affirming that termination. So in a way, it's not as if the case raised some question that had jurisprudential significance beyond this case. It wasn't like the case where we decided the one parent doctrine was unconstitutional. That case obviously was going to be important for the next 1,000 cases that came after it. In this case, it's really, did the court get it wrong with respect to this family? So in that sense, I think that's all you can read into the majority believing this was not a case that was one the court should review. It's not a case that has some reach beyond this particular family.
So I guess what I'm asking then is that, in your opinion, is that the wrong way to look at reviewing child welfare cases? That subjugates too many of them to not getting the Supreme Court's attention?
Well, I don't think that. I mean, it is the case that it's hard for most child welfare cases to get the Supreme Court's attention, because in most cases, it's like this one. The complaint is the courts below got it wrong with respect to my family. That's usually the case. There's not often some larger jurisprudentially significant question. That's true in every single kind of case, though, that comes to the Michigan Supreme Court and any state Supreme Court. So, the Court of Appeals is the appellate court where you're entitled to have the appellate court review whether the trial court erred when it made a decision in your case. So to the extent that the Supreme Court jurisdictional rules don't permit many cases to get through, it's true in child welfare, but it's true in every kind of case.
Gotcha. Yeah. Felt like when I was reading your dissent, it felt like the failure to benefit from a service could have been something that impacted cases in the future,
I'm not saying I couldn't, in this case, find principles that apply to lots more families than this particular one. Absolutely. And in fact, I think that's kind of how I wrote it. It isn't necessarily how the case came to us. The lawyer who litigated the case in the Court of Appeals didn't present those larger significant questions. Yeah.
Got it. So, not to betray any one person's confidence or anything, but I'm just curious how this dissent was generally received by your peers on the bench, jurists, other people interested in child welfare. Have you gotten some feedback on it?
I've gotten only positive feedback. I do think there are lots of, and to the extent there's negative feedback, they probably aren't calling me or writing me anyway. So there might well be negative feedback as well, but I don't see that as much. I do have a number of colleagues who are pretty interested in these issues. Child welfare is actually the one area where we have two of my colleagues are assigned as liaisons to the child welfare system. So there is a on the Michigan Supreme Court, I think there's real interest in figuring out what our part is in how we can make it work better for families.
So in this dissent, you cited the recent work of the upend movement and University of Pennsylvania law professor Dorothy Roberts, which I would say are both squarely in the abolitionist camp when it comes to child welfare, meaning that they wish to basically just end the way that we do things now. What do you think of the concept of abolishing child welfare as we know it?
I mean, again, I feel like having served on the state Supreme Court, you're kind of a generalist to the extent I feel like I've learned something about the way the child welfare system is operating in Michigan. It's from a pretty limited set of experiences and cases. And I'm also, therefore, I'm doing the same with 25 other areas of law. So I'm I kind of know a little bit about a lot. I feel a little bit like I'm no Dorothy Roberts, but I am familiar with her work and the work of other scholars, in this field, saying we probably need a do-over in how we think about child welfare. And I certainly think it's a set of ideas whose time has probably come. Like, it is definitely time to figure out if there is a way we could be doing this better. I think I said at the end of the dissent, the best way we could fix this problem is not to tweak the tests or do better training to judges, but solve the underlying problems, move the solutions upstream. I mean, it's so often the case that poverty or the inability to access the kind of services that can help you provide for your family is driving this enormous system that can end up doing a lot of harm. Obviously, we have to keep kids safe, but you can keep kids safe by also making sure their parents have housing and mental health services and the resources they need to provide for their family.
So that's sort of a vision for how child welfare, the system, could change. I'm curious also if you were starting a child welfare legal process from scratch, right? So we have this system that this is a huge, gauzy, kind of starts with whether or not to remove, right?
Right.
And there's check-ins, and then there's permanency, and then there might be a termination at the end, and right. So that's the process we have. If you were going to start again, like, how different would it look from the one we'd have today, and kind of how would it look different? What would you do?
It feels to me like this might be one of those places where court processes were all about figuring out how to support a family, not one test after another, but what are the ways in which we can connect people to resources so that they can actually, get the help they need. In problem-solving courts, which is a model we use in criminal dockets, which kind of turns the adversarial process on its head in the cases that go to those courts. We in courts think of this opportunity where we have somebody who's accused of a crime, but it's the result of a struggle with addiction or a struggle with mental health, or sometimes both, often both. And we think of our job as not punishing them, but rather connecting them to resources that they otherwise would have been unable to access, and then surrounding them and supporting them to help them succeed, and then celebrating them when they do. I mean, courts can do that. We don't have to just be adversarial places where people are dealt consequences. We could be places where we just connect people to resources. That, if I were the king of courts, I would be doing that in every courtroom across the country, connecting people to resources, surrounding them with the help they need, and then celebrating them when they succeed.
The king of courts. That we need that title somewhere. All right, last one for you, just sort of forward looking. What do you have the most optimism will change about child welfare law in the next few years, and why? Another way to ask is, like, what do you see a groundswell for that excites you?
Yeah, I feel like because I'm a generalist and I know only a little bit about everything, somebody else is probably going to have a better answer to me. But I do think there is more and more scholarship, at least, and interest from lawyers who work in the field about new models. And I do think there's interest from courts in new models. Problem-solving courts were founded by judges 30 years ago who were tired of banging their heads against the wall and feeling like the same old was not actually making a difference. And so there is a place for judges who want to see a different outcome to also lead in this area. And I wouldn't be surprised if we see some of that.
Bridget Mary McCormack, former Chief Justice of the Michigan State Supreme Court. Thanks for joining us on the Imprint Weekly Podcast.
Thank you for having me.
Thanks to former Chief Justice Bridget Mary McCormack for joining us today. The Imprint Weekly Podcast is a production of Fostering Media Connections, a California-based nonprofit that publishes The Imprint, Fostering Families Today, and operates the Youth Voices Rising program. This podcast is produced and mixed by Christine Anjoko, with music by Luke Giroux and Cyrus Elia. If you enjoyed this episode, we would love it if you consider subscribing or giving us a 5-star rating on Apple, Spotify, or wherever you download your podcasts. And we'd really appreciate if you would consider supporting our work here on the podcast and in print. Small donations from our listeners and readers go a long way towards helping us grow and cover more great stories in child welfare and youth justice. To support us, it's super easy. Just visit imprintnews.org/donate. You can follow The Imprint on Twitter and Facebook by searching the handle @TheImprintNews and visit us on the web at imprintnews.org. You can always email us at tips@imprintnews.org. I'm John Kelly, and we'll see you next week.